You walk into your sheriff's office to apply for a concealed carry permit. You've passed the background check, completed the training, done everything right, and they still deny you. Why? Because you couldn't prove you were in enough danger. That wasn't hypothetical. That was real life in New York, California, and several other states. Until the Supreme Court just dropped a 6-3 decision that's changing everything. If you carry or plan to carry, this affects you directly. Hit subscribe right now so you stay ahead of these legal changes. Today we're breaking down New York State Rifle and Pistol Association versus Bruen, the Supreme Court case that just rewrote the rules on concealed carry across America. This isn't just another legal update. This is a constitutional reset. Let's get into what actually happened. The 6-3 ruling explained, the case is New York State Rifle and Pistol Association versus Bruen, and it challenged a law that New York had on the books for more than a century. Here's how it worked. If you wanted a concealed carry permit in New York, you had to show what they called proper cause. Sounds reasonable, right? Except here's the problem. Saying you wanted to protect yourself and your family wasn't good enough? Self-defense, the most basic reason anyone would want to carry, didn't meet their standard. You had to prove something more. Maybe you were being stalked. Maybe someone made a credible threat against your life. Maybe you were a business owner transporting large amounts of cash. If your life wasn't actively in danger in a way the state found acceptable, you were denied. And who decided what was acceptable? Local officials, subjectively, with no clear guidelines. In June 2022, the Supreme Court ruled 6-3 that this violated both the Second and 14th Amendments. Justice Clarence Thomas wrote the majority opinion, and he made the standard crystal clear. If any law restricts your Second Amendment rights, it has to be consistent with the text, history, and tradition of the Constitution. Not what politicians think is safe, not what sounds reasonable to a licensing officer. It has to be rooted in how firearms were actually regulated when the Constitution was written. In plain terms, you can't be forced to justify exercising a constitutional right. The government has to justify restricting it, and New York couldn't. That's the ruling. And it set a precedent that's now being used to challenge gun laws all across the country. Ripple effects across states. This decision didn't just flip New York on its head. It triggered a wave of legal challenges nationwide. States like California, New Jersey, Hawaii, Maryland, and Massachusetts all had nearly identical laws. They operated under what's called a may issue system. That means even if you met every requirement, passed every test, cleared every background check, the state could still say no, and they did, constantly. The approval process was entirely subjective, left up to whoever was sitting behind the desk that day. Now, because of Bruen, those states are being forced to shift to a shall-issue model. That means if you meet the objective legal criteria, training, background check, clean record, they have to issue the permit, period. No more discretion. No more personal opinions from local sheriffs or police chiefs deciding who needs a gun. But several states aren't rolling over quietly. Instead of accepting the ruling, they're passing new laws designed to make carrying as difficult as possible without technically violating the Supreme Court's decision. New York responded by creating a massive list of so-called sensitive places where you can't carry, even with a valid permit. We're talking Times Square, all public transit, every park, every bar, libraries, polling places, and houses of worship. The list is so long that critics say it effectively bans concealed carry in most of the state. When that law was challenged, the Supreme Court declined to step in, at least for now, so the legal battle moved to the lower courts, where it's still being fought today. The ruling opened the door, but the fight to actually walk through it is far from over. Text, history, and tradition. The new legal test. The most critical part of this Supreme Court decision isn't just what it struck down, it's the new legal framework it created for every gun law moving forward. From now on, any court reviewing a firearms regulation has to apply a very specific test. They have to ask two questions. First, does this law align with the original text of the Constitution? And second, does it reflect how firearms were actually regulated in the history and tradition of early America? That means judges can no longer rely on modern safety arguments or what feels reasonable in today's political climate. They have to look back at the 1700s and 1800s and find a historical precedent. So if a state wants to ban certain magazines, restrict where you can carry, or limit what kind of firearms you can own, They need to show that similar laws existed during the founding era. That's an incredibly high bar, and it's already causing laws to fall. Federal courts have struck down magazine capacity limits, transportation restrictions, and other regulations because the states couldn't point to anything remotely similar from that time period. This standard, text, history, and tradition is now the lens through which every Second Amendment case will be viewed, and it's already reshaping gun rights litigation across the entire country. Impact on everyday carriers. For gun owners in states like Texas, Florida, Arizona, or Tennessee, this ruling doesn't change much day to day. Those states already had straightforward permitting processes, and some don't even require permits anymore. But if you live in a state that's been restrictive for decades, this is massive. You no longer have to convince a government official that your life is worth protecting. You don't need to prove you're important enough or threatened enough to deserve your Second Amendment rights. If you're a law-abiding citizen who meets the basic standards, that's the end of the conversation. This decision has already restored access to thousands of people who were denied permits for reasons that had nothing to do with safety or qualifications. People who were told no simply because the state didn't think their reason was good enough. But not every state is complying willingly. Some are throwing up new obstacles: higher fees, longer wait times, more required training hours, mandatory reference letters, additional background check layers. They're not calling it a denial anymore. They're just making the process so slow, expensive, and frustrating that fewer people can make it through. And while these tactics are being challenged in court, they're still in effect. The Supreme Court gave gun owners a major victory, but state governments are doing everything they can to delay and dilute it. That's why staying informed isn't optional anymore. You need to know what's happening in your state, what rights you actually have, and when those rights are being quietly chipped away. The legal avalanche that's coming. This case isn't the final word. It's the opening move in a much bigger legal war. Because of the Bruen decision, courts across the country are now being forced to revisit dozens of gun laws that were considered settled just a few years ago. We're talking about magazine capacity restrictions, the kind California and New Jersey have that limit you to 10 rounds. Assault weapon bans that target firearms based on how they look, not how they function. Mandatory waiting periods that apply even if you already own guns and already passed multiple background checks. Storage laws that dictate how you keep firearms in your own home. Transport restrictions that make it nearly impossible to legally move a gun from point A to point B. All of these are now on the chopping block, and we're already seeing results. A federal court in California struck down the state's magazine ban, ruling it unconstitutional under the text, history, and tradition standard. That's not a small win. That's a major state law getting thrown out entirely. And California isn't alone. There are active cases in Illinois, Maryland, Massachusetts, and Oregon challenging similar laws. As these cases work their way up through the appellate courts, we're going to see the Supreme Court define just how far this new framework goes. The question isn't whether more laws will be challenged. They will. The question is, how many will survive? This wasn't just a ruling. It was the start of a legal chain reaction that could reshape gun rights in this country for the next generation. Conclusion. Let's be honest. This isn't over. The opposition isn't backing down. States that want tighter gun control are already drafting new legislation that technically follows the Supreme Court's ruling, but still makes it harder for law-abiding citizens to exercise their rights. They're getting creative with definitions, expanding restricted zones, and burying people in red tape. And the media? They're going to frame every legal challenge, every new ruling, every court decision in a way that fuels confusion and fear. That's exactly why staying informed matters more now than it ever has. Being a responsible gun owner in 2025 means more than just knowing how to handle your firearms safely. It means understanding the laws in your state. It means knowing what rights you actually have and recognizing when those rights are being quietly eroded. And it means standing with the community that's fighting to protect those rights for your kids and grandkids. We need to keep backing the organizations that are doing the hard legal work. Gun Owners of America, Firearms Policy Coalition, Second Amendment Foundation. These groups are the ones filing lawsuits, challenging bad laws, and winning cases that protect all of us. But it doesn't stop with donations. You need to share accurate information. Talk to people in your life who don't understand what's really happening. Correct the record when someone repeats a headline that isn't true. Because when we stay engaged and informed, we don't just protect our rights, we strengthen them for everyone. Now I want to hear from you. Do you think this ruling was long overdue? Has your state made changes since Bruen? And are they making it easier or harder to carry? Drop your thoughts in the comments. I read every single one. If this video helped you understand what's actually going on, hit the like button and share it with someone who needs to know their rights. Thanks for watching.